Hi, I'm Steve Schindler.
I'm Katie Wilson-Milne.
Welcome to the Art Law Podcast, a monthly podcast exploring the places where art intersects with and interferes with the law.
And vice versa. The Art Law Podcast is sponsored by the law firm of Schindler, Cohen & Hochman, LLP, a premier litigation and art law boutique in New York City.
So we approached his attorney to ask her what's going on. So she pro bono represented us in housing court. So she took care of this, and as she was understanding the spectrum and the situation, she basically one day came to the loading dock and she had this bright idea, light bulb moment, and she said, there is a law, VARA. We can probably save and preserve your art under VARA. So she explained it to Jonathan, and there were a few artists in the loading dock, Z-Mad and a bunch of others. So she started to talk to all of them individually, and everybody was like, there is a law that is saying that we have the right to preserve our art? And she was like, yes, there is. So that's how the adventure started. And pretty much Jerry Wolkoff celebrated the variance after City Council, and the next day he was served with papers that we, a group of artists, had filed in federal court.
A federal judge in Brooklyn just ruled that aerosol artists were entitled to millions of dollars in damages for the destruction of their graffiti art on a building that they did not own. Today on the podcast, we're going to talk about that case, the 5Pointz case, and the moral rights at play.
So, Katie, what are moral rights?
Moral rights are a bundle of rights, apart from economic rights, personal to the creator of a work of art. These rights allow the creator to protect and control what happens to the art, regardless of who owns the physical art. Some of these rights are controlling the public display, any modifications, the right to be credited accurately for art you create, and to prevent destruction or mutilation.
So wait a second. We have these in the United States? That feels sort of unconstitutional, doesn't it?
Yes, that's been said, Steve. And some courts have questioned the applicability of moral rights under the Fifth Amendment, which prohibits government takings. And we'll get to what the U.S. allows in more detail in a minute. But moral rights are more often and for much longer recognized in Europe. In fact, they originate in France, starting after the French Revolution, which actually makes a lot of sense. France has a very different view of the law's role to protect individual dignity than in the United States. France's droit moral laws, which are their moral rights laws, are some of the most expansive and protective. They are perpetual, they are unwaivable, and they are unassignable. And these dignity-based laws protect artists based on the idea that an artist puts some of her or himself into the art they create, and then that art goes out into the world, but they still have a right to protect the piece of themselves that's in that art going forward. So how do we come to have moral rights in the United States is the question.
Well, Katie, in the 1980s, the United States was getting a lot of pressure, particularly from the tech industry, to sign on to the Berne Convention for Literary and Artistic Works. The Berne Convention is an agreement among a lot of member nations to provide equal protections and rights across their jurisdictions to the authors of literary and artistic works. The Berne Convention provides creators such as authors, musicians, poets, painters, etc., with the means to control how their works are used, by whom, and on what terms. And the Berne Convention includes the moral rights of authorship and integrity, or the rights to be credited or not credited, and to prevent harm to the art that's created by the artist. As part of the U.S. finally agreeing to sign on to the Berne Convention in 1989, the United States was required to recognize these two categories of moral rights.
And at first, U.S. lawmakers seemed to think the U.S. copyright, unfair competition, trademark, breach of contract, defamation, and privacy laws all together, along with the smattering of state moral rights type laws, provided sufficient protections when viewed together to comply with Berne. But they really didn't. And that was highlighted by a case in 1990, a few months before the U.S. Adopted its own moral rights legislation, which we'll discuss in a minute. In the late 1980s, there was a controversy over a large Richard Serra sculpture located in Federal Plaza in downtown Manhattan. And this controversy exposed that additional legislation would need to be passed to comply with the Berne Convention's moral rights requirements. The federal government had commissioned Richard Serra to create and install an enormous steel sculpture called the Tilted Arc in the middle of Federal Plaza. Now, Federal Plaza, for those of you who haven't been there, is a very busy federal office complex. There are many employees, maybe thousands of people walking back, getting to work, going home every day, and a significant number of those thousands of employees didn't love this Tilted Arc sculpture because it was making it take a lot longer to get to lunch, to get to the subway, to get home, because they had to walk around this gigantic steel sculpture.
There's also a target for pigeons.
It was a target for pigeons. Suffice to say, it wasn't well received. And after litigation seeking to remove the sculpture and litigation by Richard Serra seeking to keep it in place, a court ordered that it be taken apart and removed. And this was days before the U.S. acceded to the Berne Convention.
One of the interesting things about that case, you might remember, is that there was no VARA, there was no Berne Convention, so Richard Serra tried to protect his work by asserting rights under the First Amendment, his right to freedom of speech, and that somehow the government was abridging that by removing his work of art, which was a form of speech. The court didn't buy that for a lot of reasons, and therefore the sculpture came down.
Right. So that case highlighted for a lot of people in the United States and Congress that there might be some additional legislation required to comply with Berne and to actually enforce any moral rights in the United States. So in 1990, the Visual Artists' Rights Act was signed into law as an amendment to existing copyright law and provided authors of works of visual art the rights of attribution and integrity. This is a much more limited moral rights regime than exists in Europe, but it is the first federal one in the United States.
And so let's start with a discussion of what these rights apply to, or what kind of works that they apply to. Because VARA is very specific, and it specifically defines the works that get VARA protection, which
we should just say we're going to refer to the Visual Artists' Rights Act as VARA.
Yes, as we always do. So the works of art that VARA generally protects are pictorial, graphic, or sculptural originals and limited editions up to 200. It doesn't protect copies and posters and anything relating to merchandising or commercialization of art. So let's take a look at what are the rights that VARA protects. The first is the right of attribution. So basically, attribution rights under VARA means the right to be identified as the author of your own work, to prevent the use of your name as an author on a work that's not yours, and also to prevent the use of your name on a work that you created but that may have been distorted, mutilated, or modified so that the work that remains would be prejudicial to your honor or reputation. There are also two integrity rights that are recognized by VARA. The right to prevent the intentional distortion, mutilation, or modification of visual art that's prejudicial to the author's honor or reputation, and the right to prevent any intentional or grossly negligent destruction of a work of recognized stature. So one of the questions is, what does it mean to be a work of recognized stature? Because it's not defined in VARA. And courts have struggled with this.
And to determine what harms an artist's honor and reputation. Those are not technical legal words.
Right. So courts generally have held that for recognized stature, the artist must show that their art has stature, and that the stature is recognized by art experts, other members of the art world, or some cross-section of society. Unlike in Europe, VARA rights survive during the life of the author. They can't be transferred to anyone else, although the author may waive them so that they don't apply.
Right. You know, these rights could seem kind of un-American, I think, to some people, Steve. I mean, that they are a right to control what owners do with their private property, right?
Of course, and I think that's what courts struggle with. Until recently, the general consensus was that there were so many loopholes to VARA which we'll talk about a little bit later, that it didn't really provide artists with that much protection. But a recent lawsuit that we'll talk about today has given Vera some life. But we don't just want to talk about the legal disputes and issues. We want to tell the story of the artist who created the iconic 5Pointz aerosol art building in Long Island City, its meaning to the artistic history of New York City, and ultimately its destruction. And then we will interrogate whether Vera or moral rights generally make sense, even under the most compelling facts that existed in the 5Pointz case.
So we have three guests to help us tell the story of 5Pointz. The New York aerosol artist Jonathan Cohen, also known as Mears One, Marie-Cécile Fougeot, who worked with the 5Pointz artist for years and is an artist representative, and Renee Vara, who is an art expert and was an expert testifying in the 5Pointz lawsuit at trial. So 5Pointz was an aerosol art mecca. The building, referred to as 5Pointz, was originally a factory for water meters built in the 1890s. It had many iterations in its life, from being a vibrant factory to being abandoned to housing offices, and eventually becoming a site for world-famous graffiti artists to descend on and paint or write. And we'll hear more about that now.
So I was painting pieces, for the most part illegally. I was doing either tracksides, abandoned buildings, pretty much wherever we could find a space. Some artists took it upon themselves to ask landlords for permission to do their buildings. I didn't really take that route. And at some point I wanted to try to push my craft, instead of just doing lettering, to do more of a production-based wall. And I reached out to several artists, asked them where. They told me of a place in Queens called Fun Factory. And I went to this place and I performed my first production, or as you would say, which is not only lettering but background as well. Didn't have too much knowledge of it. It was 94 maybe. It was the same location as to what would become 5Pointz. This gentleman that ran it would get artists that were arrested doing graffiti, and they would meet there, and then they would go in a little bus he had and clean walls throughout New York. According to him, he had to buff a piece one day, and he saw beauty in it and asked the owner if we could let some of the artists doing community service paint murals on this factory. And he didn't see any wrong, and he let them do it. And then Fun Factory was born, and it became a pro-graffiti aerosol art kind of venture. Some artists were skeptical because of that. Some artists embraced it because there was a lack of walls, and Fun Factory took off. I painted there, I did several productions, and I soon found that he had pretty much zero knowledge of the art form. The gentleman, Pat DeLillo, who ran that organization, he'd have his personal taste, but he would lean on me for advice. And the more time I spent painting there, the more he would lean on me. And I kind of became a sub-curator in some form. And at one point, I kind of backed off as well due to personal reasons and stepped away. 2001, I think, he had a falling out with the landlord and was asked to leave. And the building started to get bombed and tagged up due to that little squabble they had. And the landlord made a public statement that he had nothing against the artist or the art form, but he didn't want that gentleman running it. Anyone wanting to step up to the plate, feel free to contact him, and he would let it continue. And several months went by. It wasn't something that I initially jumped on. I started to weigh it in my head and think about it. And at that point, I reached out to him. We had a quick meeting in the loading dock, a handshake, and the landlord said, okay, go ahead. I just don't want any religious, pornography, or political content. Fair enough. I got keys to a little closet, aka my office, which, became headquarters, and the program started. I think it was a Tuesday I took over. He came for a quick site visit to see, because he didn't know me and he wanted to. And he's like, when are you going to start something? I said, Saturday. And I made phone calls. That Saturday we did our first event. I think it was about 30 artists came out. which for the time was amazing. I think on a good day at Fun Factory, there would be maybe 2 or 3 artists painting. So to have 30 artists come out in one day and completely pretty much cover the ground level around the building, he was impressed. I had no idea what 5Pointz would become. All I knew is that I wanted to come up with a name that didn't put the graffiti label on the property and didn't give someone an idea, they categorize us and stuff. So I was like, 5 boroughs coming to one point, 5Pointz. Sounds good. And it was tough in the beginning. I had resistance from street taggers too. Like I'd get there and the tagger would go over a mural. So it took a lot of hard work, a lot of covering up, destroyed murals and addressing situations, reaching out to artists, trying to talk to artists that knew artists, and getting the respect. Because you have to have ultimately the respect of the street as well as the artists that are going to be performing there. Otherwise, you're not going to grow. And once, that hard efforts went, into play, artists started to do better work. And the game of aerosol art is very competitive and very ego-driven, which is good and bad. And due to that, the level of art naturally rose on its own. And as artists started to perform better, I started to realize, if you give them more time to run, if you're bringing more viewers and things that fluff an ego, you're going to see better work. And the artwork started to get better. The work started to last longer. In some cases, artists that performed amazingly, I gave them the rights to certain walls. Like they would do it over the next year, And that spread not only through the 5 boroughs, through the entire world. And then artists were planning vacations around coming to 5Pointz to save their money to come to 5Pointz to leave work on what was a museum. I let everybody paint. And I think that was what created the community. It enabled people to feel comfortable. Some people were even in enabling everyone to paint, some people were still scared. Like it was open for them but they were still scared because the level rose so much. Obviously, if you're not good, it wouldn't last long. It would rotate quicker, but they would come back and push their craft. I saw artists start and grow to become amazing aerosol artists in the 12 years I was there.
So when did 5Pointz take off? I mean, when did either of you start to notice that people were coming, spectators were coming, art fans were coming?
Clear tour buses. So started to see foot tours, bike tours, tour buses, and like school. It was over.
Families. But I think what happened in 2009. So from 2002 to 2005, there was a rapid growth in the quality of the art, in the knowledge of the existence of the building, of Mears as a curator, of 5Pointz being the place you wanted to paint at if you wanted to make a statement. And then in 2009, there was an accident. One of the staircase collapsed. The staircase collapsed April 6th of 2009. So by summer of 2009, Gerald Wolkoff says, start again. You guys start again. At that point, I remember that summer, and I think Mears slept at 5Pointz for 2 months. You still have pictures of him falling asleep in the loading dock next to a ladder because he was getting artists from all over to come. They had lift. So they were, and Christian Cortez and one of his pieces, which are in the case, did one of his pieces at night, 3 nights in a row, because he was working on weekdays. So on the lift with Mears driving the list, other volunteers. And that's another thing that started happening where community support took in, and a construction company would stop by and give us 5 gallons of buff paint. A graffiti fan who's a super would bring us little pump because the loading dock would get floated and it was never fixed. Everything was done organically. And I think that really it was a second life. Like 5Pointz took a whole new direction, and really starting that moment, the crowds grew rapidly. The amount of schools reaching out, asking to do tours and walk through, universities, and then tourism was insane. And for tours, basically we had an email set up, and I started really getting involved in 2009, and I was entering and scheduling all of it.
The wall on the side of Davis Street that was elevated above, alongside the train, that was a high-profile, in-your-face spot. So it would change a few times a year. And like I said, it evolved. I didn't go into it having any idea that it would become nearly as large as it did and affect me on an emotional level, like a human being would. But it did,
But a lot of artists, when I interviewed them, they were very cognizant of what wall they were getting, how high profile it was. And like any mural, they were very focused on site specificity. And that was also about building prestige in their portfolio. It's like if they got a great wall, then they would do a better work and spend more time on it and more paint and more money and make it a higher kind of quality than a smaller area. And, that's the basic elements to curatorial practice. I mean, those are the same fundamentals that we use in a museum or in an art fair or in a gallery. And it was operable there on a day-to-day level. I mean, Lady Pink testified that,
Yep.
and it's really incredible to read her testimony because she talked about how that spot faces PS1. And it was kind of like a face-off between the graffiti vernacular art world that she rose up in, that has now become institutionalized, and the institutionalized fine art world. And she knew it, and she was playing with that. And it's
that's
really
great.
quite amazing to listen to her.
And one last thing, too, in the flip, sometimes the artists, like even Cortez, would come and not want to commit to something amazing, have a bag of scrap paint, and just say, hey, let me get something I could just mess around with. I have the itch, and then you could go over it tomorrow. So, it was very organic. It was very ever-evolving,
But every artist knew that their work was going to be up for a certain amount of time. There was no dispute or confusion. Then you've talked a little bit about your interactions with the building owner over time, or the landlord, which seem, from what you've said so far, pretty positive, right? He gives you this space. He says, I leave it to you. Make your art. I'm not going to get involved if
There
you
was
follow
no
my 3
interaction.
rules.
There was very
Pretty
little.
much.
I've talked to him maybe, I could count on one hand in 12 years how many times we spoke.
So at some point, this sort of hands-off, you do what you want to do relationship shifts. And that's in 2013, right?
2013,
So tell us what happens in 2013.
So 209 rebirth of 5Pointz. The attention, the foot traffic, the art quality is unstoppable. A huge amount of attention from TV shows, from press. And we start doing, on top of the graffiti program or art program, we start curating events. And we're representing every element of hip hop for free for the community every summer. And we did up to 48 events a summer.
Tell
with
us
no
about some of
budget.
the high
Yes,
profile.
some of the highlights. So Mears, as any true hip hop head from Queens or the Bronx or Brooklyn, did not just do graffiti. He's a break dancer and also dabbled a little bit with MCing. So Dynamic Rocker is one of the biggest old school New York breakdancing crew. We partnered with them. So it started organically where they would come and rehearse in the loading dock. What better background than beautiful art when you're rehearsing and training your crew? And it led to them saying, we were like, why don't you start doing some of your events here rather than struggling to find venues? Do it here. So battles, crew battles, they started an event called Rep Your Style, where a breakdancer could face off with a tap dancer, which could face off with a ballerina. With jury coming in, renowned dancers. We had people from Alvin Ailey's company coming as judges, people working with Bill T. Jones coming as judges, concert.
And this was still just the two of you organizing this?
With volunteers and friends. So I basically put a calendar together usually by May. Time Out would pick it up and publish it. And then every week on Thursday, Time Out would tweet and remind people what we were doing. Every event were free. We were not selling drinks or food or any of that. It was all about the art.
And you're not getting paid still.
None of us are getting paid. We're doing it for the love, and that's the beauty of New York. For us to be able to see a family of, 2 parents, 5 kids, spending a whole day in situ for free and seeing art being created, having their kids learn basic steps of breakdancing, and then deciding to stay a little later after they had dinner at the diner for a concert. And so the biggest event was
40 years.
40 years of hip hop.
Right.
August 2013, Summer Stage calls us, and they're like, Cool Herc wants to perform at 5Pointz. And we said, okay, well, Marley Marl is our resident DJ, so he's going to welcome Cool Herc on our behalf. And we hosted over 7,000 people. And that was 40 years of hip hop, and it was published in the New York Times.
There was filming there too,
Oh,
right?
yes, a lot. So, example, Now You See Me is a movie directed by Louis Leterrier, released in 2013, was in situ for 3 months. Production crews, building on the roof, catering and holding was on the 5th floor. 4th floor was the green room. And we directed the entire production company, Summit Entertainment, to G&M Realty. And he rented the building and was paid for that. Louis Leterrier, the director, hired Mears and a few artists of 5Pointz as artists on some art he wanted extra on the building, which was done on vinyl and then removed. And Mears and Zimad and a few others did a mural for the movie.
So while 5Pointz was becoming world famous, Long Island City was gentrifying and becoming a hot real estate market. The building owner, Gerald Wolkoff, had been waiting for this moment, and certainly with some help from the fame of the 5Pointz art itself, did the completely unsurprising thing of wanting to develop the property and make a ton of money. How he did this, given the history of 5Pointz, though, is a bit more surprising and troubling.
I think it's important to know that Mears was a resident of Long Island City, so was I.
Okay.
So you have the Long Island City Facebook page, etc. And I see that there is a community board meeting hearing at PS1 in the case of 5Pointz G&M Realty variance application.
When was this? And
May 2013.
Okay.
We have gotten no phone call, no conversation with Mr. Wolkoff. I found out from a Facebook post. So we're like, okay, it's not a guarantee that he's getting variance, but something is happening. And of course, 5Pointz was extremely important to the community and to us. But at Long Island City and the gentrification and overdevelopment was something that affected us as residents as well. So we spread the word and we decided to go to the hearing, which was at PS1. The G&M Realty team took 3 rows between the architect, the consultant, the lawyers. So most of the people who wanted to come and testify could not even enter. And that was the first hearing. Then there was a second hearing in Sunnyside where a lot of people were mobilized, and the community board ended up voting against granting the variance. But as we all know, the CB recommendation has no value. Then there were meetings between local politician and the Wolkoff team, and the local councilman wrote a letter of recommendation saying that after meeting with the Wolkoff family, he was confident that the artists were going to be taken care of, that it was going to be 100% union jobs, and also that affordable housing would increase should the variance be granted and the number of units be granted. So it went to
Because the proposal was to build condominiums, to tear down the warehouse.
luxury rental.
Luxury rental.
And to go higher, to give you an idea, if you look at Long Island City from the FDR and you look at Citibank, which was for the longest time the highest tower, the variance and the request are for both towers, which was granted, to be higher than Citibank, to give you kind of an idea.
Wow.
So it went to Queensborough president with this letter of recommendation from the president of the community board saying now we're on board with the Wolkoff, Councilman Jimmy Van Bramer on board with Wolkoff, so Queen's president granted the variance. Then we went to Department of Building, had a hearing. We're told there was going to be a follow-up, no follow-up, granted. And then it went to City Council. We were told we were going to get 2 community hearings. We got 1. And there was again a letter of recommendation, which stated that some of the gallery space was going to be given to 5Pointz artists, studios were going to be given to 5Pointz artists. So this was all said, but never discussed, agreed. There were never meetings. So it was all news to us. And City Council voted yes, and he got his variance by end of September 2013.
The artists and their supporters did their best to stop the destruction of 5Pointz. There were efforts to buy the building, get it landmark status, and figure out ways to remove all the art where possible. And one day the artist learned there was actually another way to save 5Pointz too.
By August, some eviction notice were thrown in the loading dock. And this attorney who had come to the loading dock always said, if you ever have a question, call me. I'll be more than happy to answer. So we approached this attorney to ask her what's going on. So she pro bono represented us in housing court because we were tenant. Free rent tenant, but tenant. And so our lease was guaranteed to be honored until December 2013, which is really important as a date because that meant that physically we were allowed to be at 5Pointz and to have our program till 2013 December.
And artists were still writing throughout this time?
Yes, absolutely. So she took care of this, and as she was understanding the spectrum and the situation, she basically one day came to the loading dock and she had this bright idea, light bulb moment, and she said, there is a law, VARA. We can probably save and preserve your art under VARA. So she explained it to Jonathan, and there were a few artists in the loading dock, Z-Mad and a bunch of others. So she started to talk to all of them individually, and everybody was like, there is a law that is saying that we have the right to preserve our art? And she was like, yes, there is. So that's how the adventure started. And pretty much Jerry Wolkoff celebrated the variance after City Council, and the next day he was served with papers that we, a group of artists, had filed in federal court. I think when the variance was granted, it became real for all of us. And being explained VARA and this right to preserve art and to prevent destruction of art, it was pretty amazing because you would think because of the art form, most artists don't want to be in a courtroom. It was obviously Jonathan's decision because he's the lead plaintiff, so Mears won. And then a lot of artists were like, let's do this. I mean, I'm not going to tell you we had an understanding and we knew that 5 years later, we didn't know what we were necessarily going for or the lengths, but I think to think that in 1990s that law was passed and created, it would have been foolish of us not to actually reach out and file. And the artists were animated about it and nervous about starting a legal procedure, nervous about having to go in court and potentially testify, but animated and hopeful. And we were really told in the way it was presented to us, we're told that there was a good chance we would, if nothing else, buy time to maybe document and preserve, but that you had to go to the law. We had done everything else. So that's how it kind of came about.
So in November 2013, the artists working at 5Pointz learned that the landlord, Gerald Wolkoff, obtained a variance that would allow him to tear down the existing factory and build luxury apartments. After they had failed to stop this from happening by either obtaining landmark status or even purchasing the building, they finally marched into court in Brooklyn in November of 2013 and asked federal judge Frederick Block to issue an injunction under VARA to prevent the destruction of their art. The plaintiffs in that case were Jonathan Cohn, who you've heard from, otherwise known as Mears One, and a number of the other artists who had painted on 5Pointz. Gerald Wolkoff and his various companies were the defendants. So there was a preliminary injunction hearing in November of 2013 before Judge Block. And at the conclusion of that hearing, Judge Block denied the plaintiff's request for a preliminary injunction, effectively allowing the landlord to tear down the building and build apartments. The judge seemed troubled by having to do that because he recognized that this was important art and that these were indeed artists who likely had recognized stature, although he didn't find it at the hearing. What he eventually found was that under the standard for issuing a preliminary injunction, which requires irreparable harm, which means that money won't compensate the artist for their loss. He found that, in fact, money would ultimately compensate the artist for their losses, and therefore that was the main reason for him not granting a preliminary injunction. He also commented along the way that the art was perhaps transient and recognized that the artists who put the works up had to have had some notion that they were going to be just temporary. None of this, however, is part of the Vera statute. After Judge Block denied plaintiff's motion for a preliminary injunction, the landlord wasted no time and basically went out the next day, hired a crew with whitewash, and then whitewashed the entire building. And as we'll hear from our guests, it was whitewashed in a very haphazard manner, which was viewed as very disrespectful by the artists.
And no one knew what was happening.
Right. It was done in the middle of the night, essentially, and it was done even though there was really no urgency to it. As soon as the judge denied the injunction, the landlord went out and essentially destroyed all of the art.
So we get the oral decision on a Friday morning. You can tell that people are upset. They're reading, and when you read in the newspaper coverage, if you're not legal savvy, you don't necessarily understand. So now we have a responsibility, as usual, on a weekend to welcome hundreds and thousands of people that are coming. So last minute we decide to do Show Your Love to 5Pointz Appreciation Day. And we put it together very rapidly. We get a DJ to volunteer, we get speakers, and it's kind of like, let's get everybody together, let's be positive, let's be hopeful, let's celebrate the art. Nobody could paint, but we were allowed to have music, etc. We decided to put this together, we put it on social media, we share it on Twitter, etc. And then the Friday afternoon, a lot of NYPD buses show up and barricades are being dropped off all over Davis Street and all around the building. So I reached out to the precinct and I'm like, what's going on? And they're like, well, we're being told that you guys are going to riot. We don't want an Occupy Wall Street situation. So I went personally to see the captain and I said, we've been here 12 years. There's never been an issue, and I can guarantee you there's not going to be an issue. But you can't have barricades and cop cars everywhere. It's not fair. And so I said, tell me, what are the perimeters? He said, I would like for you guys to be done by 5 p.m. because sundown. I'm like, done, deal. So they did assign a few officers from the precinct whom we knew, who were, jamming and listening to music and talking to people. And we had a very successful day where people expressed and kept on signing landmark form. And everybody went home uplifted, in some ways, whether it was realistic. We're all romantics, we're artists too. And then, Monday morning we woke up and we were waiting anxiously about, is there a decision in writing from the judge yet? And then Tuesday morning, the 19th of November at 6:30 in the morning, Mir's phone starts ringing, my phone starts ringing, and we're being told 5Pointz is white. It's white.
We raced over there, and they were still whitewashing when I got there. They had whitewashed the entire back lot. They did all of Davis Street. They were doing
Crane Street,
Jackson Avenue. They were just rounding on Crane Street.
Yeah, they were on the lift.
And I ran up. I stopped the car. I got out and I hit the emergency stop because I know how to operate the lifts. And then I went to proceed to the next machine that was further down, and a cop pulls me over. I didn't see him, and he was gonna arrest me. And he's like, I could arrest you. I said, all I did was hit the emergency stop. All you have to do is pull the emergency brake. One of his workers had been there, and when I hit the emergency brake, he was a fan of us.
Yeah,
he took the key. So they literally were stuck up there. She talked to the officer. He wound up letting me go.
But they were not from the precinct. So this is what is interesting too. They were not from our local precinct. So police protection was granted to Wolkoff and his workers all night. They started around 2 o'clock in the morning, apparently. And so you had several cars, but they were not from our precinct. So they didn't know us. And so I called our attorney, of course, right away, and then I called the precinct. And then the precinct, through radio, reached out to those guys and said, it's time for you to pack it up and go back wherever you came from.
Oh, wow. Where did they come from, do you know?
From another precinct in Queens.
So Judge Block left open in denying the preliminary injunction that if the plaintiffs were able to prove that these were works of recognized stature, that he would consider granting damages, money damages, to the plaintiffs. So after the case proceeded for some time, eventually there was a trial. At the conclusion of the trial, Judge Block issued his decision granting the plaintiffs $6.7 million for a violation of their VERA rights.
We think the largest damages ever granted under VERA.
So in issuing his decision, Judge Block found that the plaintiff artists' VERA rights had, in fact, been violated. And as a consequence, he awarded them $150,000 for each of the 45 works that the landlord destroyed, for a total of $6.75 million. And it was clear in reading the judge's opinion that he was influenced by the fact of the landlord's willful destruction of the works, the fact that the landlord went out and whitewashed the works when there was really no urgency at the moment to do so, had a tremendous effect on the judge. Now, looking at the judge's two decisions together, it's very hard to reconcile them because initially he was asked to enjoin the destruction of these works. And under VERA, that is the remedy. If an artist creates a work of recognized stature, he has the right, or she has the right, to go to court and seek an order preventing the destruction of that work. So it's just somewhat peculiar and hard to reconcile the fact that Judge Block ultimately found that VERA applied and the artist's rights had been violated, but rather than preventing the destruction of the works of art as he might have done, instead he awarded them a hefty amount of damages.
Yeah, and we should add or remind the audience that artists also have the right to go to court to prevent any mutilation or modification of the art if it harms their honor or reputation. So these two sort of amorphous rights to stop conduct that the artist had, but the judge here just wasn't willing to do that, even though he later found that the VERA rights were in fact violated. And all he could do at that point was pay the artist because the work was gone. So, Renee, we would love to hear from you about your work in the trial. And as Steve and I have talked about on this podcast, one of the really complex aspects of VERA is there's this standard called recognized stature, which the statute declines to define or explain. And so it's been left to courts and litigants to try to figure out what it means when something is a work of recognized stature and is thus entitled to protection under VERA, the Visual Artists' Rights Act. So that was how you came into the case, right?
So I was contacted, I guess, about 4 years ago, right?
Yep, exactly.
After the injunction.
So what were you hired to do?
As an art expert.
To answer the question
of recognized stature.
Okay, so that
and testify to that, yes. But in the end, I helped assemble the whole kind of team through people I know and had expertise, because in sorting out recognized stature, I mean, where do you start? Where I would start was immersing myself in these emails and looking at the kind of cross-section of society that was visiting in it, and kind of moving beyond the legal records and the depositions and everything like that, and then just trying to formulate a methodology that I thought would be consistent with both kind of professional practices like connoisseurship, but also, I mean, one of the things that has been kicked around is this conversation about it's about the artwork, and rather than just the context of the artwork in the artist's career trajectory. So I basically, did a lot of reading and then tried to come up with a methodology that used connoisseurship as a basis, but also looked at different kinds of values, like what kinds of values do we associate with art? And, developed a kind of consistent process with looking at the artist's career, the artist's kind of style, the materials.
For each aerosol artist.
For each aerosol artist,
a
for
plaintiff.
each artwork. And then I interviewed some of them. I created dossiers of each one of them. So, what were their career highlights? What were their other works that were recognized? Who recognized them? So, and also, a big piece of my original expert testimony was about Jonathan's role as a curator and how that in and of itself lent significance and stature to the individual artworks. Mears became a well-known artist and a well-known curator because of 5Pointz. I mean, he has both. He ended up having kind of both of those reputations.
Right.
So his artwork being his artwork, but as a curator looking at all of these artists, most artists don't care about other artists, quite frankly. They're very into their own craft and everything, and they're looking at it for reference, but they're not actually looking at it to be a connoisseur. And Jonathan, in that process of looking at all these artists and their portfolios and overseeing all this, in and of itself, he became respected as a connoisseur and as an expert in aerosol art. So what I did was I just kind of leaned a little bit. I mean, I didn't really know, what the right answer was, but I knew that, there was things we do every day when we work with emerging artists. When you look at an artwork, how do you figure out whether it's good, better, or best? And so putting that kind of lens on, using it and applying it and articulating it in a paper, but leaning on the prior case history. With the two-tiered elements. The first was merit, talking about what merit meant to me, what merit means in the art world to most people, and then the second tier was it recognized by three communities? One, an art expert, i.e. me. Two, other art professionals, which also theoretically I applied Jonathan
Right.
but any other art professionals that might have written about him, or blogs, or critics, or curators. And then the third was a cross-section of society, and that's the one that was kind of like the hardest to interpret. But, I used a variety of different things there, and that's where a lot of commentary, and I think it's interesting, the thing that keeps on being brought out is the use of social media. Yep. So that was a creative thing that I didn't know because, where is the bar? It's always about, like, what is the breaking point of when it goes from unrecognized to recognized. Yeah. But I evaluated every artwork according to all three, and almost every single artist, in my mind, met all three standards, but the law only requires one. You only need to be recognized by one of the three communities. So that's what I did.
So, Steve, this is a kind of a crazy case. What do we make of all this?
Well, I think that the 5Pointz decision is somewhat emblematic of the way judges have struggled with the interpretation of Vera. Ultimately, it leaves me with a very uneasy feeling because I think when you look at the judge's two decisions, his decision to deny the artists a preliminary injunction and the decision ultimately having allowed the works to be destroyed essentially, then giving the artist damages, it's just very hard to reconcile those two things because ultimately the judge found that Vera applied to these works and that they were works of recognized stature.
But he wouldn't prevent it.
And under the statute, I think he should have prevented them from being destroyed. Now that is a very tough thing for a judge to do, admittedly, because he would essentially be going up against the right of a property owner to develop a building that he owned and that he was entitled to develop under the New York City ordinances and regulations. So it was a tough place for the judge to be in, but it's very difficult to reconcile his two decisions.
So maybe this is another case like the Berkshire Museum controversy, which we discussed on an earlier podcast, where the facts are just so bad. I mean, the landlord behaved so poorly. These artists behaved incredibly well. Everything was done with permission. It was iconic art. But the law used to address these terrible facts might not really be the best fit. And that's because, I think we need to talk about how Vera fits into existing U.S. copyright law. And it may not be the best fit. I mean, copyright law in the United States developed to encourage innovation and creation for the public good. And it did this by offering artists intellectual property rights, the idea being that they'd be more likely to create and move society forward if they had a limited right to control what happened to their output. It really wasn't, and it isn't, about the artists at all. But in France, on the other hand, where the idea of moral rights really comes from, these laws are actually explicitly about protecting the artist's dignity, with the idea that art is really part of the creator's identity and that that identity is entitled to protection. So the copyright schemes of France and the US come from very, very different places, and that explains how moral rights evolved. So then Vera comes along and tries to fit this very European-style right into the US legal system, which is a very private property, individual liberty-oriented system, and into U.S. copyright law, which has nothing at all to do with protecting artists.
Right, and even with that said, Vera is still clearly written in a way that has the public in mind. The requirements of recognized stature needed to prevent the destruction of a work of art acknowledges the public interest in preserving the valuable works of art, not just for the artist, but for the public. To prevent distortion or mutilation of works of art under Vera, however, the harm to the art must hurt the artist's honor or reputation, and that's really about the artist. Now, in the case of art being placed on buildings, which is what we have here, the law is actually even more confusing. If a work of art is on a piece of real property that can be removed without being destroyed, the building owner only needs to give the artist 90 days' notice and an opportunity to take the work down. If the artist fails to do that, the building owner can then remove it himself. That seems pretty reasonable to me if we're in the business of granting moral rights. But if a work of art cannot be removed without it being destroyed, then essentially tough luck. Unless the artist signed a written waiver of her Vera rights acknowledging that the work might be destroyed in the future, the building owner can't destroy the work until the artist dies and her Vera rights cease.
That seems a little surprising, given how few people understand the contours of Vera and the general lack of written agreements for anything in the fine art world, right, Steve? I mean, especially street art. So let me get this right. The building owner would be legally barred from doing anything with the building or repainting it or renovating it if that destroyed the art, if this art is of what we call recognized stature, right?
That's what the statute says.
And courts don't really like this rule. So they've tried to get around it in a few ways. One is the general rule, at least in most courts, that Vera does not protect works that are created illegally. So graffiti not permitted by a building owner, unlike in the case in 5Pointz where it was permitted, is not protected by Vera. Now that's a rule that we don't find in the statute itself, but judges have applied because they're very uncomfortable with protecting illegal art. You also have what's called the statutory public presentation exception. And that is a section of Vera that says modifications to a work of art that would otherwise be protected by Vera that occur just because of its public presentation, meaning how it's lit or where it's located, are not protectable under Vera. So an example of that is a sculpture in a public park that's site-specific, and it has to be moved because the park is being reorganized or re-landscaped. A fair reading of Vera would say that's not a violation of Vera, even though it was originally intended for that space. Some courts have applied the public presentation exception to exempt all site-specific art from Vera, where it can't be removed from the site without destruction. We're not sure that that's a faithful reading of Vera, but some courts have applied that standard. And of course, the recognized stature and honor and reputation standards that you find in Vera to prevent mutilation or destruction of a work are very tough standards to meet. What does recognized stature mean? What does honor and reputation mean? Those are fact-intensive inquiries that can also serve as a bar to Vera protections. And we should also mention that the Vera statute contemplates fair use defenses, just like you find in other copyright infringement claims.
So suffice it to say, there are a lot of ways to get around Vera.
So the 5-point decision gives Vera real teeth in a way that these other exceptions have failed to give it teeth in many decisions in the past. And one thing we talked about is why do we think that happened here? And as you said, Steve, the judge was really trying to find a balance between punishing the landlord, Gerald Walkoff, for behavior he found reprehensible, which was coming out in the middle of the night and destroying all this art when he absolutely didn't need to do that. He could have given the artist notice. They could have come to some compromise about trying to save some of the art. And instead he just ruined it all months before that had to happen. And the judge didn't like that, and he wanted to punish him. In a way he could punish him was by making him pay $6.7 million. But the judge also really could not find it in himself to tell the landlord that he couldn't do with his building what he wanted to do with his building. And so you have this sort of uneasy balance of sort of complying with VERA, sort of enforcing VERA rights, but not to the full extent of the literal statutory language, because courts just feel uncomfortable doing that in the United States.
Right, and I think if you read the judge's preliminary injunction decision, he really was reaching out to the parties to try to work something out. And I think he thought that by not issuing an injunction, that somehow the landlord would act reasonably and the artists would continue to act reasonably, and they would work out a solution. And there were solutions to be worked out. It turns out there was testimony at trial that most of these works could have been removed. The technology exists to remove the works intact from the building, and with time, and they had the time, they could have done that. So I think the judge was disappointed that the parties didn't try to work something out. Now, what he has effectively done, assuming that this holds up on appeal, is to give notice to landlords that there are some real teeth to VERA, and perhaps encouraging settlements or resolutions in the future, because now an artist has the leverage to go to a building owner and say, I want to figure out a way to save this art, because the alternative for you could be some pretty hefty damages.
So it kind of seems like VERA now is an expensive tax, right? I mean, that's how it's applying in this case.
Yeah, that's the way it worked out in this case.
It's a real estate tax, a really, really high one.
It's a cost of doing business, but if you're developing luxury apartment buildings in New York City, it's probably not even that significant a tax.
I guess we should also just raise the potential risk, or what some people have said is a potential risk, that this could discourage landlords from allowing street art to occur in New York City, and that doesn't seem like the desirable result either, right? So now that a landlord knows that, okay, even if I give permission for someone to use a building and paint on it and create this street artscape, unless I get the exact right waiver, ahead of time, and I follow the letter of the law and the waiver says this correct thing, I'm stuck, and I'll either have to pay millions of dollars if the work becomes famous, or I won't be able to develop my building. I can see that, if landlords really become aware of this decision, which I think they will, it may mean less street art for all of us.
It may, or it may mean that landlords have to hire good art lawyers to draft waivers that will protect them.
Well, right. We're available. We're also pro artist rights, though, so there's a delicate balance here, and I don't think this decision resolves that completely.
But I do think that in the best world, you could have a meeting of minds between a landlord who would like to see her building used for street art and artists who would like to use the building for that purpose, who could sit down and work out what would become of the art in the event the use had to be changed.
Yeah, more paper. We encourage more paper.
A little bit more paper. And that's it for today's podcast.
We will share information about the 5Pointz building and litigation on the podcast website, artlawpodcast.com, and in the show notes, as well as some more information about our guests.
And please subscribe to us on iTunes or wherever you get your podcasts. And send us feedback at podcast@schlaw.com. And if you like what you hear, give us a 5-star rating. And finally, we want to thank our fabulous producer, Jackie Santos, for making us sound so good.
Until next time, I'm Katie Wilson-Milne.
And I'm Steve Schindler, bringing you the Art Law Podcast, a podcast exploring the places where art intersects with and interferes with the law.
And vice versa.